property or real property that you own, and that of your source of income, sorry about that, and also for your investments. And the rules and the regulations in which we look at differ by the type of interest. So if we're looking at real estate, we're looking at several different types of factors. We're looking at distance, and then depending on the distance of whatever the decision is being made to your real property interest, there's 3 different sets of criteria that we would apply to those specific analysis. The other one's stock, common one that comes up a lot, and you typically have to own a significant amount of stock available. It's 3% of the common stock available of a particular company that would trigger a conflict of interest under the Political Reform Act. And the last point here is that materiality is presumed, meaning that there's a general presumption that it is material if your direct financial interests, so that's your income, your business, real property, investments, are the subject of the governmental decision. So if it's approval for a conditional use permit at a property you own, your property is directly named in that governmental decision, and therefore there's a presumption that it is material financial interest under the Political Reform Act, as an example. The third step is the effect on the official the same as the public generally? And this is really recognizing the fact that a lot of decisions that come before public entities, public boards, councils, commissions, have impact a wide array of individuals that can be very similar to, the public official themselves. So, for instance, if the city is considering, upgrading their sidewalks, and they have a citywide plan, and it's going to be over a 10-year period, the plan is impacting everyone. And so, although, as a council member or the planning commissioner, you live within the city, and maybe, if you're a property owner, you would benefit directly from this decision, because you're doing all of the sidewalks, or even if you're only doing half, it would be deemed under the Political Reform Act to be your interest is no different than that of the public generally. And I think this makes sense. This is balancing or acknowledging really the fact that as public officials, you all live in the jurisdictions in which you're trying to help make improvements to and bring change to. So to say that just because it's impacting your community and you may benefit personally, but if everyone else is going, if a significant segment of the public is also going to be benefiting, you should be able to participate in that decision. And the fourth step is the official participating in the making, or using their position to influence? And I think this is, for the first step, making is pretty straightforward. If you're voting on a particular issue, you're making the decision. You're participating in the making, that's akin to sort of the preliminary discussions or the potential meetings with staff or other members of the public regarding a particular issue. That would be deemed to be participating in the making, or using your position to influence. So if you're going around, hopefully not talking to other council members, but if you're going around to try and garner public support for a particular issue, that would be using your position of influence governmental decisions. So as I mentioned before, if we go through those 4 steps and we determine, yes, you as a public official have a qualifying financial interest, which gives you a conflict of interest under the Political Reform Act, the PRA requires that you recuse yourself from that decision. And so what that means is you, during the meeting in which the item is coming for, I should take a step back. So once we've identified that you have a conflict of interest under the Political Reform Act, you're not allowed to be involved in any part of the discussions, meetings, anything addressing or dealing with that particular decision. And when that decision comes before the council or the commission or the board for that particular issue, once that agenda item is read, you have to recuse yourself. And the recusal process is you have to publicly state that you have a conflict of interest. You have to identify what that interest is. And depending on the type of interest, there are different requirements. So for real property, there are specific criteria that you have to name. If it's not your home address, it would be the location with enough detail. So the actual street address or APN number. And then once you identify your financial interest, that's the disqualifying interest, you have to recuse yourself from the dais, actually leave the room unless the matter is on a consent agenda, and you're not allowed to speak on that matter. There is one very, very narrow exception, and it's to comment on personal interest specific. If you have a personal business, and these are very specific criteria when you can actually speak. And so if you feel compelled to participate in the decision, if we've identified that you have a conflict of interest, please reach out to me or our office so that we can make sure that we're meeting the regulation requirements and that this exception applies. And I think so. I think I'll try and do questions at the end of each section. So I think this would be a good part to take a break and ask if there are any questions regarding a conflict of interest under the Political Reform Act.
Hi, yes, Trevor, this is Councilmember Moran. Specifically, can you give us an example, or like I've seen in certain occasions when either council members or planning commissioners, when they have something that comes up in front of them and they recuse themselves, what is the difference between recusing themselves out of the room to the audience and still be able to participate only as, not as commissioners or council members, but as members of the public? What is the difference? Can you be more specific and give us an example?
The example I can think of is if you are a business owner, there's a specific regulation that addresses when you're a business owner and you own, and there's specific requirements in regards to what qualifies. If you have technically a conflict of interest, you can speak on behalf of your business interest in favor of a specific decision. I'll say that is the exception. It rarely applies to when a commissioner or a council member has a conflict of interest. Generally, they're going to be required to recuse themselves through the procedures I just went through by removing themselves from the room, but before doing that, also identifying what their conflict is. Does that answer your question to a certain extent, or would you like a different example?
I think that does it for now. Just in case if I have another question, I'll make sure I bring it up again. Thanks.
Okay. I will just add that having a conflict of interest and being able to speak publicly as a member of the public to represent your own personal interest is really only happens in very rare circumstances, and there's very specific criteria to allow that to happen. Just to reiterate that generally, if you have a conflict of interest, the recusal procedures here are going to be applicable.
Catherine Shell Rodriguez.
Go ahead, Catherine.
This is a hypothetical, but I think over the years I've seen an example of this where we have 5 on the council and 3 declare a conflict of interest. What do we do to get a quorum?
So if there are, So to take your example, if we have 5 council members and 3 have a conflict of interest on the particular matter, the third, we do need 3 votes for it to be a quorum and to approve it. What we would do is have to do a randomized drawing or selection. So you would go through this recusal process, and then once they identify their conflict of interest for the record, we would then do a randomized selection to pick one that would give the council its quorum to make a decision. So out of the 3 that were conflicted, there would be 1 selected randomly. Some jurisdictions have literally drawn straws, and whoever has the shortest straw or the longest straw is the one that is allowed to participate with the conflict in that decision. But it has to be a randomized selection process. And then those other 2 that aren't selected do need to leave the room for that matter. So the one that was selected randomly is allowed to participate just for that particular item. Okay, so the next section is going to be conflict of interest in contracts. And this is what's known as 1090. So if we think about the Political Reform Act conflict of interest, the PRA is focused on your financial interest. And that's a key point. So financial interest in real property, income, business, investments. Section 1090 conflicts of interest are focused on contracts specifically. And so what it says is it prohibits public officials and employees from having financial interest in contracts made by them in their official capacity. This is a broad application. So this is renewals, extensions, anything involving a contract itself. If a public official has a financial interest in that contract, and if there's no exemption or other exception that applies, the city is prohibited from entering into that contract. So to think about it, if under the Political Reform Act, if you have financial conflict of interest, you yourself as a public official are prohibited from participating in that governmental decision. The difference with 1090 is if you have a financial interest as a public official in the contract, the entire city, the city as itself, is prohibited from entering into that contract with the individual. And we'll go into more in depth of what 1090 says. And so this summarizes what I just went over. So it's the legislative body itself, for purposes of 1090, is deemed to make all agency contracts. So every contract that the city enters into that is approved, even if it's approved by a delegation to the city manager, the council itself is deemed to make these contracts. And this is the note here at the bottom goes back to that example. So just because a council member does not participate in the making of the contract or recuses themselves from any discussions regarding the contract, the 1090 does not consider those factors. 1090 is focused merely on the fact of, is there a contract? Does the public official have a financial interest in that contract? And if so, regardless of whether you participate or not, the city is prohibited from entering into that contract. And similar to some of the exceptions under conflict of interest, where there's some nuances for specific situations where, we just mentioned that a council member may be able to participate by speaking on behalf of their own interests. 1090 has a specific list of what are called non-interest exemptions and remote exemptions. And these are statutory exemptions, meaning they're defined by statute as saying what specific types of interests, financial interests, do not qualify for or do not cause the city to not be able to enter into a contract for purposes of 1090. And here are some of the examples. And so this is, they're very specific, and I don't want to need to go through all of these, but for your reference, it's important to recognize that if you own a business, if you have investments with some companies or own shares of some other companies, or if you have any type of financial interest in other entities, it's important to be mindful of what type of work those entities are doing and who they're contracting with. And if there's any potential for them to do work for the city, you want to raise those issues to either myself or the city manager as soon as possible so we can dive into whether the 1090 provisions apply. And so the remote exceptions examples here are saying you have a financial interest, but we deem those financial interests to be minimal. So what 1090 is trying to prevent is from you personally benefiting financially from a contract that's being entered into by the city. So the remote interests are saying, if you take one employee or officer for nonprofit, saying, okay, most likely the nonprofit, if they're entering into a contract with the city, it's probably going to be for something of public service or public good. And so for that purposes, 1090 is saying we don't think you're going to be profiting, if you're a nonprofit, from entering into that contract. The non-interest exemptions are saying these are just sort of common sense things where if it's your spouse, ownership of less than 3% of the stock or constituting less than 5% of your income, you're deemed to be not financially interested in that contract. And again, these are statutory definitions. It's just important to be mindful of if you have a financial interest in another entity, this entity is potentially going to be doing business with the city, something we need to be made aware of very early on so we can complete the analysis to determine whether a 1090 exemption or conflict is going to occur. So with the Political Reform Act, conflict of interest violations, those typically are fines if it's, and those are enforced by the FEPC. 1090 violations, the consequences are that the contract itself that's entered into that is in violation of Section 1090 is void and unenforceable. It also says any monies paid must be paid back to the public agency itself. That's what's commonly known as disgorgement, and that's all monies, not just what their profit margin was or their overhead. So any money that's been paid pursuant to the contract that was made in violation of 1090 has to be repaid back to the city. And then the public agency may keep the benefit of the contract. So one of the harshest examples I've seen of this was several years ago. There was a significant parking structure that was being constructed to the tune of $5.5 to $6 million. And one entity brought a Section 1090 claim against the prime contractor who had constructed the parking garage and claimed that because of a financial interest of one of the public officials that had been the approving agency that entered into the contract with the prime contractor, that the contract was void and unenforceable. And the appellate courts agreed. And so the end result was the public agency got to keep the finished parking garage, and that prime contractor had to repay every single dollar. I think it was around $5.5 to $6 million back to the public agency itself. And so those are harsh consequences. And you may be thinking, well, hey, that seems like a good way that maybe a city could do types of, contracts, getting free things built. But willful violations of 1090 are considered criminal offenses. So while the consequences of a 1090 violation are harsh on whoever is entering into the contract with the city in the form of disgorgement of any monies paid. Willful violations the penalties are equally as harsh, and it's a permanent disqualification from holding office, and they can be criminally prosecuted, which means essentially jail time and or significant fine. So it's important to be mindful of when we're looking at 1090 that we identify these interests early, because we want to make sure that any contract that's coming for approval either by the council or by the city manager, that we're identifying whether or not there is a 1090 issue, and being able to document and say, no, there is no 1090 issue, or there is. And that way we can get out in front of it. And this is just an interesting note that as of, I think, 2018, FPPC now has jurisdiction and can issue administrative fines. And they also offer 1090 advice now, too. And this is something that, as a public official, if we have questions, if it's a gray area and we're not too sure, this is a type of situation where our office would be more than happy to prepare a request for the FPPC and or the Attorney General to get an opinion. And what's nice about getting that opinion is it's sort of immunity. So if we go to the FPPC, we outlay all the facts that are specific to your situation. We ask them for advice, whether it's, and we can do this under the Political Reform Act, financial interest questions, as well as 1090. And if the FPPC opines in their response that there is no 1090 violation or there is no conflict of interest, you as a public official can act based upon that advice from the FPPC. Are there any 1090 questions?
If I may, I have actually a couple of questions that I think that could be connected. One of them is how far, for instance, would it not be considered conflict of interest as far as family, cousins, not immediate family members, for it to not be considered conflict of interest? If someone is bringing a contract to the city or to the council. And the other question is thinking of if someone close to my family is interested in land outside of the current city limits, but thinking of the future, possibly to have it annexed into the city, how would that affect me or any family member due to conflict of interest?
So for the first question, I think we should do it in two sections. So under the Political Reform Act, financial interest, unless you have an interest in your family member business, or unless, so for under the Political Reform Act, financial interest as far as what we're concerned as income or otherwise, it would be your spouse or partner and dependent children. For 1090, it's focused on income, so your financial interest. And again, we would focus on those same criteria. It would be your spouse or your dependent children. If it is a brother or a sister, we would want to look at that a little bit further and say, well, okay, what is your relationship with them? Are they dependent? It may not be as clear-cut. There's no specific regulation that says if it's your sibling and they own like 60% of the business that's coming before you, you're precluded from dealing with them. We would want to be very fact-specific. So I don't want to go off on a tangent here, but generally we're focused on your spouse or legal partner and your dependent children. If it involves a sibling, a parent, a grandparent, aunt or uncle, we would want to look at the facts surrounding that situation. And it may not be a conflict under the Political Reform Act or 1090. It may be a common law conflict, which is, we'll get to that further down, but it's, can you act with disinterested zeal is the catchphrase. And under common law conflicts, there are, it's very subjective. So it's, can you act with disinterested zeal? That requires you as a public official to make that determination. I, as an attorney, obviously, if we feel there's a violation, we'll provide that advice to you. But, that's really incumbent on the public official themselves to make that determination. For your question regarding the annexation, again, for FPPC Political Reform Act purposes, the focus is on group property interests of yourself, or it would be one half of your spouse or legal partner. And if your dependent children happen to own property too, that would apply. But generally, if it's a brother or sister, mother, father, typically that doesn't trigger 1090 or Political Reform Act violations, with the caveat, again, that we would want to know more facts. Because it's all, like I mentioned at the beginning, these analyses are so fact-specific that nuances in different circumstances could be material to the decision of whether there is a conflict or not. Okay, we're moving on to the next section, which is campaign contributions. And I will say that these campaign contributions, as of January 1st, 2021, there are new local campaign default contribution rules that apply to every city and county in California, unless the city opts to adopt their own campaign contribution requirements. So the law says that going forward from January 1st, the campaign contribution restrictions that apply to elected state and assembly members, so for the California State Assembly and Senate, now apply to local officials. So if any of you have questions, I would refer you to the FPPC has a very good fact sheet regarding what those contribution amount limits are. Those limits are set per election. So it's important to remember that for, it's not just on the year. You do keep yearly totals, quarterly totals for your individual campaigns and those contributions, but the maximum contribution limits that are established by the law apply for the election cycles. That would be the next 2022 election, unless there's a separate special or election that's called. So the basic rule for specific to conflict of interest in campaign contributions is that you're disqualified from making a decision involving a license, permit, or entitlement if the official accepted a campaign contribution exceeding $250 in the preceding month. And there is an exception for directly elected officials. That would be council members. So this exception doesn't apply to planning commissioners since they're appointed. And so it does apply. There's a nuance here. So this restriction would apply if if the permit, entitlement, license came before the Livingston City Council. But if you were sitting on a different type of governmental entity as the city's representative, like the local air management quality district, if someone had made a contribution to you and they were coming in front of that specific board, because you're not directly elected to that board, you're appointed to that board, this $250 requirement would apply. Section D is dealing with when you leave office. And so if from the day you leave your office as city council member or planning commissioner, there's a 1-year prohibition on lobbying the city. And lobbying is really defined as being paid for by another entity to represent their interests. So not your interests, but their interests. Even if you support their cause, if you're being paid to do it, there's a 1-year prohibition on doing that. And This doesn't apply, and then this, again, like I mentioned, it applies only if compensating and representing another person. This next prohibition is dealing with using your public office to negotiate your next job. So public officials and employees are prohibited from being involved in governmental decisions directly relating to a prospective employer. And this is really a common sense approach. So if, let's say, a business is coming before for a permit from the city, in your mind, you're interested in maybe working for them, but don't know if they have an opening, haven't talked to anyone at that agency, there's no conflict or prohibition there. It really applies to when you've taken a meaningful step to engage in discussing potential employment with them. So that could be something as obvious as submitting an application or a resume and cover letter to that specific entity, or even beginning some conversations with key figures or with contacts at that particular agency. If you're exploring the potential for employment there, that's somewhat of a gray area, but I would caution that to be safe and to apply with the spirit of the Political Reform Act, that if you've done any meaningful step towards engaging a potential employer, you really should not be involved with any decision regarding that employer or prospective employer that comes before the council or the Planning Commission. And I think for bribery here, this is a concept I think most people are familiar with, but it is receiving anything of value or advantage, present or prospective advantage or value, and not, in receiving that for a specific action. And I think a lot of times this gets tricky in the sense of campaign contributions and where that line is drawn. And I think the clearest example is if someone says, I'm donating money to you because I like your position on clean air. That's a completely permissible campaign contribution, and they're giving it to you because they're supporting of your position on particular issues. When this becomes bribery is if I'm making this campaign contribution only if you vote a particular way. And I hope that's about as clear as an example I can give between what's a permissible campaign contribution and then what amounts to bribery. I will say that most of the time campaign contributions are just given and there's no expectation. But for bribery purposes, it doesn't have to just be monetary. So if there is any indication of what I call quid pro quo, meaning I'll do this for you if you do this for me, that is bribery. And so there's a complete prohibition against any form of bribery. It is a criminal offense and something that would be prosecuted either by the district attorney or potentially the Attorney General's office. Or, if it has bigger implications, it would be a federal offense too, as we've seen in some cases recently out of LA involving LA City Council members. All right, so we have a quiz, and it's not a poll, so honor system, and hopefully you can answer them yourselves, and then I'll go through the answer, unless someone wants to be brave enough and raise their hand and speak. I'd be happy to entertain that. So question number one is, the city council and the city manager will be attending a conference where they want to make a contract with the vendor to make city pins that they can all wear to the meeting. A council member owns a business that manufactures decorative pins and offers to provide the pins at a discount. Can the city enter into an agreement with the council member? This is a softball question if you're paying attention. So no, this is a clear 1090 issue. because it's the council member's business, he obviously has a direct financial interest, and there's a contract. The contract would be, even if it's a purchase order, that's deemed a contract with the council member's company. And so, no, the city is prohibited from entering into that contract. And if it did enter into that contract, the city would be able to, and the pins were delivered, theoretically, the city could keep the pins, but the council member's business would have to repay any money given to it by the city back to the city. So the second question is, a consultant seeks a contract for services from the city council. A council member received a $300 campaign contribution from the consultant 3 years ago. Can the council member participate in consideration of the contract? See some nods. Yes. Council members are directly elected by the voters, so the prohibition against receiving campaign contributions does not apply. So that ends our first section, which deals with conflicts of interest under the Political Reform Act, conflicts of interest in contracts, which is section 1090, as well as covering just some simple things with conflicts of interest with campaign contributions, as well as the basic bribery concept and prohibition. Does anyone have any questions regarding anything we just covered? All right. So the next section is laws related to claiming prerequisites of office. And we're going to cover what gifts are, honoraria, misuse of public funds, mass mailing restrictions, and this is one of the oldest prohibitions, which is accepting free or discounted transportation from a transportation company. So with gifts, the basic rule is that public officials' employees may not accept gifts from a single source during a calendar year in excess of $520. This limit used to be $480, I believe, last year for the last 2 years. FPPC just increased this amount to $520, which will be the amount, I believe, until 2022. So for the next 2 years, the gift limit will be $520. And this is a hard limit. So if you receive a gift card from a person that's given to you as a public official for $520, you're not allowed to accept another dollar or penny in any form, whether it's monetary or a gift, from that individual for the rest of the calendar year. And it's just important to remember that gifts in excess of $50 are required to be reported on your Form 700. And I think this is a general concept everyone can understand. So what is a gift? And it's anything of value that provides a personal benefit to you as a public official, in which the person giving it to doesn't receive equivalent consideration. And so this could be rebates, discounts, and that would be if they're given to you specific as a public official. So if the mayor walks in to buy dinner at a restaurant and they say, hey, mayor, we love you, we're giving you 20% off, or we're giving 50% off your meal because you're the mayor, that will qualify as a gift. However, if the mayor's going out to dinner and everyone that night gets 20% off or 50% off because of the promotion being offered to everyone, not just the mayor because of their role as mayor, then that does not qualify as a gift. So this is an important part, that a gift is considered received when the public official has actual possession of the gift and doesn't intend to return it or give it away, or when the official takes an action exercising specific direction or control on how the gift is going to be used. And so if you're uncertain of the value of the gift, you think it may be over the $520 threshold, if you don't want to report the gift, safest thing to do is not accept the gift, or you can donate it to charity. But if you donate it to charity, it's important that you don't direct on how it's used by charity, or that specific charity, excuse me. And these are the exemptions. So, gifts returned, gifts from family members, if it's informational material, inheritance, legally it's not considered a gift for conflict of interest purposes. Leave credits aren't considered gifts. Any prize that you receive in a bona fide competition, and this could even be a competition that's run by the city, is not considered a gift. If you're lucky enough to win the lotto, that's not considered a gift. That's considered a bona fide competition. Here's some more exemptions, and I think these are really common sense situations, and it's important just when you are going through your roles as public officials, it's important to be mindful of if something or someone is going to be giving something to you, really take time in that brief moment before you accept or decline the gift to understand in what context it's being given to you. Its value. I think all of us have a pretty good understanding of value. Granted, if it's some rare statue that may look like a kid made it, I think those are different circumstances. But I think generally, if someone's handing you something that looks expensive, you may want to take a pause and say, is this under $520 worth of value? Just so that you're complying with the gift requirements set by the FTPC. And here's some more exceptions. So travel payments, if you travel as a public official, as a council member, the payments that are made for by the city, reimbursements, per diem, flights, rental cars, hotel, lodging, anything that's paid for by the city is not considered a gift. There are other types of travel payments in specific circumstances from nonprofit entities or non-governmental organizations that may also qualify as not being subject to the travel, as being deemed as a gift. And it's just important that if you are accepting travel payment from an outside entity that's not the city, so please reach out to myself so we can make sure that it complies with the FFPC regulations of not being deemed a gift. And if it is going to be deemed a gift, we need to make sure that it stays within the $520 limitation. Are there any questions on gifts or travel? Okay. Honoraria. So honoraria deals with certain situations where you are being paid to either give a speech or write an article or attend an event as your role as elected official, city manager, or even city attorney. And what this says is there's a complete ban on honoraria as an elected official. And I think a typical situation where this arises may be a university or college wants to have a speaker and they offer to give you honoraria for giving a speech, or maybe there's a conference being held and they would like you to attend in your role as council member or mayor or planning commissioner or city treasurer. You can't accept the honoraria. But with every FTPC regulation, I laugh because there are exceptions to all these prohibitions. As you recall, with conflicts of interest under the Political Reform Act, 1090, there are exceptions. So these are the exceptions to when you can receive an honoraria. And again, these to me are common sense. So if you're going, let's say you're a teacher and you're being asked as a teacher to make a presentation based upon your profession or type of specialty or some type of area of expertise, and it's your bona fide business, you're allowed to do that. You can return the honoraria. And so, as I mentioned, when you receive a gift, you can donate it or refuse it. You can also return an honoraria and not be subject to any consequences. You can donate the honoraria to the city's general fund. If you do this option, it requires that you do not direct in any way how the money that's donated. You can also donate it to a bona fide nonprofit, which means they would need to have their registered status with the IRS. Or it could be, if they're making a campaign contribution, that's also permissible. But again, that would need to be reported on your filing forms that are filed with the city. So the next section we're going to cover is misuse of public funds. And the basic rule is public officials and employees may not use public resources for private gain. And I think this makes sense. As public officials, public employees, the large part, if not all, of the monies being expended by the public entity, even if it's for supplies, are derived from taxpayers. And so there is the basic rule is trying to capture the idea of taxpayer money should be used for the public benefit, not for private gain. And that's important too in dealing with political campaigns. And it's, the government, the city cannot use public monies to promote a partisan position in an election campaign. But there is a one caveat in the sense that a public agency or the city can educate the community or the residents about specific ballot measures. And these could be ballot measures of which they were initiated by the city. So, a lot of measures or sales tax initiatives, the city can spend public monies to educate the public about those ballot measures. And this is a California Constitution prohibition, and it's public agencies may not make gifts of public funds. And the key threshold here is whether the use of public funds is for a public purpose. And there is no specific statutory definition of what public purpose is. It is broadly encompassing, meaning that the courts give great deference to the public entity in identifying what the public purpose is. So long as the agency or the city is able to identify what public purpose is being served by an expenditure, even if there are some benefits that trickle down or may benefit a private party, so long as there is a public purpose identified as being served by the expenditure, that's a permissible use of public funds. And the next prohibition under the Political Reform Act is dealing with mass mailings. A mass mailing is a tangible item that's sent or delivered. The tangible meaning has to be physical. You have to be able to hold it. And 200 or more people within a calendar month that features an elected official and which costs over $50 to make. And that includes staff time or printing materials or ink, things like that. And this is one area of the law that hasn't caught up to modern times. So at the beginning, I focused on a tangible item. So that's typically a newsletter, a mailer, a piece of paper, other type of physical item. This prohibition does not apply to email or electronic newsletters. But I think in keeping with the spirit of the law, we just want to be mindful if we are using city resources that feature elected officials, we should want to be mindful that we're not doing it in a way that can be viewed as supporting a partisan or, personally benefiting that particular elected official. So Generally, this isn't an issue anymore. I think previously when cities would send out monthly updates or newsletters, physical mail, it was just something to be mindful of if they had a picture of a council member or a mayor doing some type of work with the community or something like that. But because it doesn't apply to emails, and email seems to be the main form of communication now, typically this is not an issue. And the last section in these laws relating to claiming prerequisites of office is the oldest prohibition for public officials in California. This is a prohibition that hasn't changed, and it's in the California Constitution. And it's from the mid-1800s. It deals at a time in which there were several powerful railroad companies, and as you can imagine, they offered lots of free travel on their fancy trains to public and elected officials in California. So what the California Constitution says is public officers, so this would be the council members and city manager, city attorney, other directly elected officials of the city, are prohibited from accepting free passes or discounts from a transportation company. And this is a harsh consequence. So the minute you accept a free pass or a discount from a transportation company, you automatically forfeit your office under the California Constitution. So if there is Amtrak comes through and says, council member, we'd love to give you a ticket, free ticket to try out our new service line. The minute you accept that ticket, you have just forfeited your office as council member. And it's a harsh prohibition. It's never been changed. So it's important to remember if someone is offering you a free pass on a transportation company, because the consequences are so harsh, I would argue this would be like a discount code from even an Uber or a Lyft. If it's not being given to everyone, if it's being given to you specifically because you are a public official, you need to decline that offer with free pass or discount. What this doesn't apply to is something that applies to the general public. So if you are waiting to catch a flight and the airline company says, we will give anyone who forfeits their ticket on the next flight a free voucher for 2 additional flights, because that offer was made to everyone and not specific to you as council member or other public officials, you can accept that discount or those vouchers because that was something an option that was available to every member of the public. Now, if some airline company says, council member or mayor, we'd love to give you a free ticket to come out and check out our facility. We'd love to, make a similar facility in the city of Livingston. That's a different situation because you are being offered a free pass from a transportation company because of your position as a council member, mayor, or other elected official of the city. So were there any questions regarding that? Okay. This next quiz is based on this video, and hopefully people can hear it. And I think I have to actually exit out. It's not going to work. So I'll just go through this example. It's basically Lesino has a gift basket. He has eaten 2 items out of the gift basket. Has Leslie Noe received a gift under FTC regulations? Again, this is pretty, and then the second part of this question is the gift permissible under FTPC regulations? It's a gift basket, has, I'm assuming, cheese, wine, crackers, fruit. And so the answer to the question is yes, Leslie has exercised over control of the gift by eating the items. Assuming the gift basket is valued at under $520, it's a permissible gift she can accept. And if the gift basket is over $50, Leslie's required to report it on her Form 700. Question 5 is a council member has a T-shirts made by a screen printing business that is located 5 minutes from City Hall. A staff person offers to pick up the T-shirts and return them to the council member during regular business hours. May staff retrieve the T-shirts? And the answer is no. If you're using staff time, again, because it's for campaign T-shirts, these are a private use of public resources. So going back to that prohibition, public officials are prohibited from using public resources for either their personal or political purposes. Were there any other questions regarding what we just covered as far as gifts, prohibitions on accepting travel? All right, seeing none. The next section that's required under AB 1234 are dealing with transparency laws. That's economic disclosures under the Political Reform Act, the Brown Act, and the Public Records Act. And I think we'll probably end close to partway through the Brown Act since we're running up around 7:20 right now. So under this section, these are the public policy considerations. And I think it's important to keep these considerations when thinking about the topics we're going to cover. So economic interest disclosures, and that's the Form 700. Those are also the FEPC forms you file when you assume office, your annual Form 700, and then when you leave office. And it's based on this premise that your financial interests that are specific to you are important to be known to the public, because the public has a right to know what your interests are, because they may impact your official decision. So under this kind of premise, it seems very cumbersome sometimes when you're going through the Form 700, but it's based on this idea that the public has a right to know. And that right to know also carries down to the right to access information, which is under the the Public Records Act, which is also, acronym PRA. But the public has a right to access information so that they can understand what government is doing, what their government is doing, how they're doing it to a certain extent. And that's their right as a member of the community to understand and have access to records and information. And under the Brown Act, it's typically this is government's called the people's business under the Brown Act. And so the people have a right to be informed about the conduct of the public business. And this really goes to, posting agendas, making sure that the public has a right to comment, and comment on things that are not on the agenda, but within the subject matter jurisdiction of the city. So this is, I think, for council members, commissioners, and other elected officials of the city, all of you filled out a Form 700 when you assumed office. It's required for you to fill it out annually. It's important to remember it's a public document. And so if a member of the public requests a copy of your Form 700 that's been submitted to the city, they're allowed to access it. And This is a Form 700, some just basic key points. You're not required to list your primary home. It's important to remember to list your spouse or your domestic partner's income as a source of income to yourself, not just your own source of income. And I will say the active VC guides specific to Form 700s, not the videos themselves, but the actual appendices and also tutorial guides that they have on their website. I'd be happy to share a direct link to you for those guides. I find to be very helpful. So if you have questions regarding how to complete the Form 700, an easy way is to turn to those appendices and guides. If you have questions and feel more comfortable speaking with me, I'm more than happy to entertain your questions regarding how you would fill those Form 700s out. And hopefully this works. Another video to break up hearing me talk for the last hour. But this is John Oliver. And I apologize, it's not working. But what it essentially shows is a two-member board and holding a meeting and with no one present and going through all the steps. They say the Pledge of Allegiance, they take roll, they offer public comment, and there's no one that's in the meeting except for the two individuals. And why I like showing that video as a segue into the Brown Act is because it shows their commitment to following the rules. And so the Brown Act establishes these set of rules that deal with how City Council, its Planning Commission, its other standing bodies are required to operate. And it's so that the public has an opportunity to understand what their government is doing, to have the opportunity to be able to speak and voice their opinion or views, both of anything within the subject matter and jurisdiction of the city or on a particular matter being considered by the council or commission. And so that takes us to the Ralph M. Brown Act, which this is Ralph M. Brown. And I just wanted to read what is the intent of the Ralph M. Brown Act, which is codified in the beginning of the Brown Act, which says, in enacting this chapter, the legislature finds and declares that public commissions, boards and councils, and other public agencies in this state exist to aid in the conduct of the people's business. It is the intent of the law that their actions be taken openly and that the deliberations be conducted openly. The people of the state do not yield their sovereignty to the agencies which serve them. The people in delegating authority do not give their public servants the right to decide what is good for the people to know and what is not good for them to know. The people insist on remaining informed so that they may retain control over the instruments they have created. So I think most council members and commissioners are familiar with the Brown Act. It applies very specific requirements on when a meeting occurs, how it can occur, and then if it is a meeting, it requires it to be public, requires an agenda, and then it limits the discussion to an action to what's on that agenda. Again, this is all going back to the intent of it's the people's business, and therefore they should have a right to understand when and where things are going to be happening and have the opportunity to participate in those governmental decisions. And this is a specific government code section that just says very much, it sort of reiterates the point that all meetings of the council or the commission shall be open and public, and all persons shall be permitted to attend any meeting of the legislative body except as otherwise provided by the Brown Act. And the except would be situations dealing with closed session or in emergency meeting situations where there's really no real way in which the public could attend. So the Brown Act applies to the legislative body of a public agency, and that is boards, councils, committees, commissions, standing, and advisory bodies if those advisory bodies are ongoing and permanent. The Brown Act does not apply to temporary advisory committees comprised of less than a quorum of the legislative body. Sometimes these are referred to as ad hoc committees because they usually contain two members of the legislative body. It's important that these temporary advisory committees are limited in scope to a specific task. They don't automatically renew, or it's not an every year a new budget ad hoc committee is formed. It needs specific to a task and not self-renewing. And it's limited in scope and duration. And this is a summary of generally what is a legislative body, governing body, appointed body, standing committee, what is not a legislative body, and an ad hoc committee. So what is a meeting? And it is any congregation of a majority of the members of a legislative body at the same time, location, including teleconferencing, to hear, discuss, deliberate, or take action on any item that is within the subject matter jurisdiction of the legislative body. And so what this means is if there are 3 council members or 3 planning commissioners in the same place, if you begin to discuss anything that is within the subject matter jurisdiction of the city council or the planning commission, that is a meeting. But if you show up to a barbecue and there's a majority of the council or the planning commission, you just want to make sure that you do not discuss anything that's within the subject matter jurisdiction of the council or the commission, and then that would not qualify as a meeting. And so there are 4 types of meetings: regular meetings, special meetings, emergency meetings, and adjourned meetings. Regular meetings occur at the time set by ordinance of the city or by law or some other type of formal enaction, where the council meets on the first and third Tuesday of the month. The planning commission has the stipulated meeting times. Those require 72-hour notice, and during those meetings, you're allowed to discuss anything within the subject matter jurisdiction of the council or commission. Special meetings can also be called. They require 24-hour notice. Things that you cannot discuss at a special meeting are salary schedules, compensation, but you can hold a special meeting to discuss the city's budget or other budgetary issues. Emergency meetings, these are really in rare circumstances where immediate action is needed on behalf of the council. You see this a lot of times in situations where there's a natural disaster, a huge flood or fire or mass power outage. Emergency meetings don't require any prior notice. Typically, if members of the press or media have been requested to be notified of agendas, it requires, at least we recommend an hour, and providing that notice to the different media outlets, the paper, and anyone else that's requested to receive agendas, if it's possible. If the situation is so dire that that's not possible, the law allows for you to proceed with the emergency meeting. And just to be respectful everyone's time, I think we'll just end this session here at meetings, and we'll pick it up for the next session. Are there any questions up to this point about Form 700, Brown Act, generally types of meetings? All right, so seeing none, I'll I'll send it back to you, Mayor, for the end of this.
Thank you, Trevor. Thank you, everybody, for participating in tonight's training workshop session. Remember, tomorrow will be on for our second day of training, which is a continuation of what we've been going over today. Just a reminder, tomorrow's training also begins at 6 p.m. So at this moment, if there's no...
I have a question, Mr. Mayor.
What was that again?
I have a question, Mr. Mayor.
Yeah, go ahead.
Yeah, it's Bob Wallace. I didn't see a roll call of the commissioners, and when we all signed on, there were only 4 commissioners present, unless somebody used their phone number and I didn't recognize. So how are we going to get credit for those who kept the roll call?
For the record, if, I know we have the names here of who is participating in the training, but if you want, just for the record, do a roll call for Planning Commission, and I believe and then the Recreation Commission. Yeah, okay. So I'm getting a word from our clerk that she did write all the names on Zoom here down for the record, along with our, I believe some of the Recreation Commissioners might be on here too as well. And treasurer and our other elected officials. So but we'll definitely have that on the record. All their names are popping up here. I can see it on the screen, okay?
Hey, Mayor, this is Councilmember King. I know you couldn't hear me earlier, but did you guys mark me down?
Yes.
Okay, perfect. Thank you.
Thank you. So at this time, if there's no further questions, we're going to adjourn our training meeting at 7:33 p.m., and I'll see you guys tomorrow. Thank you.
Thank you, sir.
Good night.
Bye, Trevor.